Islamic classification of the contract we will discuss. After reading this, we will be able to describe what are the bases of classification of the contracts in Islamic law. We'll see the basis of classification, time, payment, delivery of contracts, transfer of right to use, that is use of right, and contract of partnership, security and safe custody, and what is the concept of wakala and jula. This is what we are going to discuss now. We'll start with the basic of classification of contract. There are certain situations and there are certain ways of doing contracts. Classification can be dependent on the behavior and the salient feature of each classification. Refinement and enhancement of existing contract for product development in Islamic financial markets. Synergy amongst the contract to satisfy a unique and distinct need of a modern society, for example, hedging, swapping. So, how we classify the contract is first two broad categories are unilateral and one is bilateral. Unilateral is like as in the Quran and other sources we have instructions how to give the will, waivers, donations, gift. In terms of such things, there are unilateral contracts, but bilateral in terms of worker, employee, safe custody, security, partnership. Two people want to be partner, one will bring skills, the other will become, he will bring money, both will become partner and one will be appointed as manager, as mudarib. So there should be a contract. Leasing in terms of finance lease, operating lease. And in terms of sale contracts, what is the subject matter, how much cost or profit we are going to add, what is the time of payments today or in future, delivery of object on spot like today or in future, and then in terms of currency, rights, receivables, tangible assets, then discounted base sales, cost based sales, negotiated sales or cost plus. This all is the type, the different situations which will lead to different kind of contractual obligations. In terms of bilateral, of course, at least there are two parties. Consideration will be required, acceptance will be required. Purpose is of course commercial, and the gharar, that is uncertainty, this is prohibited at all. In terms of unilateral, of course, unilateral is applied on one party only. Consideration is not required at all. Offer acceptance, there is no case because it's one way of guidance. Gratuity is the purpose, and any small variation of uncertainty can be tolerated. A contract may have more than one type and classification in order to meet the various legitimate needs of the society. And from a macro perspective, a contract is essentially divided into two broad classification, that is bilateral and unilateral. Example of the bilateral is the loan that is based on the concept of Islamic concept of qarz as hasm, which is not subject to interest. Any loan of money where borrower is obliged to repay the principal plus some premium is of course prohibited in Islam, as it leads to the riba in terms of the interest. Sales contract, a lot of sale contract, as I explained you, is we have to see that any contract should not lead to riba. We call this as bay is the sale contract, involve an exchange of one commodity for another commodity. It can be for a barter trade, it can be commodity for the money or money for money, that is currency exchange. We have sale of trust, that is in Arabic we call it as amana. That is the, as Islamic commercial law, you have to be fair, honest, and you should provide full disclosure of actual price to the buyer in terms of benefit. And following these principles, sale contract normally divided into sale of trust, that is amana, and sale that are not based on trust. So sale not based on trust may arise when the price depends on bargaining skills without any reference to the cost or profit margin. So there could be a new situation. We go for contract that is cost plus. So we tell this is the cost and this is the profit margins. Sometimes we go for non-for-profit contracts. Sometimes we sell below price, discounted price, that is al-wadiya. So there are different type of contracts, which is if you see murahaba is cost plus, toliya is same, and wadiya in technical way is when you sell below cost. So it can give you a loss. That depends upon the situation, how it is going to be tackled. We have negotiated sales in terms of musawama. Musawama is you have to make on spot delivery. Payment can be spot or deferred. In terms of disclosure, no disclosure of cost is required. Price would be profit or cost or loss, but not known to the purchasers. In terms of murahaba, it's a spot transaction, and payment can be on spot or deferred. Disclosure of cost is really important. Price at cost plus markup will be showed. Toliya in terms of spot, payment can be spot and deferred, and disclosure of cost is required. Neither profit and loss will arise. Wadiya is a spot transaction, payment can be spot or deferred. Disclosure of cost is required, and sale at loss will be done based on this type of contracts. Let's talk about contract, that is the contract time of payment. It's like bay'al, muajil, that is no spot payment. It can be a deferred payment, and it can be agreed as such by two parties. We have bay'al salam, that is spot rate. Deferred payment is not allowed in such kind of contracts, and deferment of payment as per Sharia principle is not permissible because it will lead to riba. So al-arbul is a part payment. Remaining payment you can do as a deferred. Deposit will be forfeit if you will break the contract. The contract will be terminated. Al-sarf, that is in terms of currency exchange. It is allowed to make a spot payment. Deferred payment not allowed. Both counter values must be exchanged with each other on a spot rate basis. If it is on forward rate, then it is not Islamic. On the other contract, all other contracts can be on spot, on forward, and as agreed by the parties in a lawful way. In terms of time of deliveries, we can classify contract as salam and istasniya, that is for agriculture, other things. Spot, this is later in other books we will discuss what is salam, what is istasniya. Spot delivery, it will be always for the deferred delivery. Currency exchange spot rate, not deferred allowed. Other than salam and istasniya is spot delivery, and no deferred delivery will be allowed in terms of contracts. We have usufruct, that is the transfer of the right to use. So in terms of usufruct, that lessor of course must be the owner of the lease asset. The lessee with the consent of lessor can sublease the asset to a third party. And sublease asset must be for the benefit for the lessee, and the rental must be fixed and known to the both parties. Ownership risk will be borne by the lessor, and the leased asset should be treated in trust, that is amana. So you have to take care of this asset. Total damage to lease asset will render the lease contract null and void unless there is no bad intentions behind. and we will make ijara contract for this. We have operating lease, we have finance lease. The operating lease is for the rental purposes, finance lease when the asset is going to be in your custody. In terms of contract, when you do ijara coupled, when you have ijara, ownership is on the lessor and usage, risk and cost is on lessee. Rental can be fixed and floating. Ownership transfer will not be done in operating ijara, and asset no restriction in terms of provided beneficial and in terms of complaint. Finance lease is ijara coupled with an undertaking by a lessor to sell the lease asset to the lessee. This is mandatory. Ownership will be on lessor and your risk will be on lessee. It can be fixed and float, and ownership should be transferred at the particular time and no restriction provided it is beneficial and the compliant. In terms of ijara contract, transfer the right to use the particular asset from the owner to the user. And I explain you the concept of operating and finance lease. In terms of partnership, we have two concepts that will be explained in other books. That is for mudaraba and musharaka. Musharaka is a contract. Mudaraba is a contract of partnership for profit. We have musharaka. It's a sort of joint venture. How it works, this is in appropriate places we will discuss the details. So far we are discussing the contract from different angles, in terms of delivery time, in terms of partnership, in terms of security. We have hawalas, that is the transferring the right to claim for a payment of debt to another party, that is transferring. In terms of rahan is like a pledge. Kafala is someone is becoming your guaranteed person in terms of security. Wakala and Jwala is a recognized contract to do. This contract where a party engage another party to do work on their behalf. It will become like Wakala will become like an agency, principal relations. Vadiya is, of course, as we discussed, is a contract between depositor who deposit his asset and custodian who receive the deposited asset and keep it under their safe custody. This is all about the contract and their different types in terms of contractual obligations.